Latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening, South Florida. Welcome to Talk Legal, where we bring you all the latest news in the legal world. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we specialize in intellectual property law, including patents, trademarks, and copyrights, as well as elder law. You can check us out online and view all episodes of this show on our website at oltmanpatent.com. That's OLTMANPATENT.com. I'd also like to give a shout out to our other sponsor, Fresh Start Tax. Fresh Start Tax offers a full range of accounting services, including basic tax returns, as well as assistance with tax levies, wage garnishments, and any other tax-related concern. You can find out more by visiting them online at freshstarttax.com. I'd like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. If you have a question, comment, or a story that you would like to share on the air, please feel free to call us toll-free at 888-565-1470. Once again, that number is 888-565-1470. We welcome your calls. My guest in studio this evening is Tom Willis. Tom is a bankruptcy attorney. He represents debtors, and he also is a foreclosure defense attorney representing homeowners. This evening, our focus will be primarily on bankruptcy, and Tom came all the way from Doral, where his practice is, to join us this evening. So, Tom, thank you very much.
Thank you for having me. I appreciate it.
So, let's talk a little bit about your practice. You primarily represent people in bankruptcy.
That's correct.
If you could just describe a typical person that would come to you or somebody that would be considering bankruptcy.
Well, I've been practicing bankruptcy for a number of years now, but a lot of my foreclosure defense practice, as this housing crisis here in South Florida has drug on into its 6th or 7th year, a lot of my foreclosure defense practice has merged into a bankruptcy practice based on some new programs that we have here with the court system in South Florida to help people save their homes. But bankruptcy is one of my main practice areas, and unfortunately, as the economy's had problems that have drug on, it's more and more people file for bankruptcy. And I think a lot of people would be surprised at the profile of the typical debtor filing for bankruptcy today.
So if we just talk a little bit about the bankruptcy process, when someone files for bankruptcy, there's an automatic stay where any collection activity, that is bill collectors calling you or really taking any measure to try to recover their debts, must stop immediately, and that effect can be very forceful.
That's correct. As a matter of fact, this is really, the automatic stay of bankruptcy is one of the most powerful tools in the entire legal world. There's very few things where you can shut down the IRS or you know, a foreclosing bank, or many collecting actions come to an immediate grinding halt the moment you file for bankruptcy because of the automatic stay. It's an operation of federal law, and it affects not only all state courts but other federal courts as well.
And in fact, if a bill collector or a creditor tries to continue to collect a debt after the automatic stay, they can be held in contempt of court.
Yes, they can. It's very, very powerful. It's a very powerful tool, and the bankruptcy judges don't take it lightly when you bring a creditor into their courtroom who has been trying to collect on a debtor while they're still under the automatic stay.
Now, what is the effect of a bankruptcy on your credit report?
Well, that's it's a very interesting question, and it depends a lot on what was happening in that person's credit before they filed for bankruptcy. Obviously, the bankruptcy is reported on the credit to the 3 major bureaus, and it's something that stays there for a number of years. We found that the real impact of a bankruptcy is mainly only the first 2 years after filing. A curious thing about that, though, is that there's a lot of people who, at the moment they file for bankruptcy, have a lot of different debts that are in default. Payments that are way behind, not just maybe on a mortgage, but also credit cards, other types of debts that have been charged off and sent to other bill collectors. What happens is with the bankruptcy, once a bankruptcy discharge is entered, all of that negative those negative credit reporting is actually lifted from there. So future creditors or banks looking at someone, analyzing their credit, will see the bankruptcy, but the other stuff will be wiped out. We've actually seen some people's credit improve after getting their bankruptcy discharge.
So what is the difference? We've all heard the term Chapter 7, Chapter 13. What's the difference between the two?
Chapter 7 and Chapter 13 are two very different animals. Chapter 7 is a liquidation process where in one fell swoop, all your debts, your unsecured debts at least, are immediately wiped out. A Chapter 13 is a little bit like a chapter, what everybody hears in the news about big corporations like General Motors who go through a Chapter 11 and reorganize and restructure their debts. Chapter 13 is like that, but for the individual instead of the corporation. It's a way a person can propose a plan to the bankruptcy court to pay back some or all of their debts over a 3 to 5 year period and bring themselves current on all their bills and really clean up their entire financial situation.
So a primary difference between Chapter 7 and Chapter 13 is generally that Chapter 7 is going to be ideal for people that don't have a lot of income or assets, and Chapter 13 is going to be for people that might have a number of assets that they want to protect.
That's absolutely correct. And one of the things, too, is there's actually a ceiling in Chapter 7 of how much money a person can make and still qualify for Chapter 7. Now, before you ask the next question that most of my clients ask me is, what is that ceiling? As any good lawyer is going to say, it depends.
Right.
Thanks to the federal government, there's actually a pretty complicated formula to determine whether or not someone qualifies, and it's not just a bright line of income. First of all, the bankruptcy code looks to where you live. Obviously, someone in a major metropolitan area with that zip code can have a higher median income and qualify versus someone living in a rural area. They also take into account what mortgages or certain bills someone may be paying, how many dependents they have. But as a general rule, I say this. A person or a family making less than $50,000, I can tell them with a high degree of assurance, you'll probably be able to qualify for Chapter 7 without any problem. And if you make below $30,000, without a doubt. Someone making over a six-figure income, especially as you get to 120, 130,000, even with a lot of mortgage and secured debts, it becomes very, very difficult for them to squeeze under that Chapter 7 threshold, and generally they have to file a 13 instead of a 7.
So there's something that we call priority debtors. Those are debtors that get paid first before others. If you want to talk a little bit about that.
Correct. The bankruptcy code allows a debtor in a Chapter 13 case. Remember, we're talking about a 13 now and the repayment plans under the 13. Certain taxes, for example, your income taxes, payroll taxes, or something like payments to a condominium association, something that are considered types of secured debts, can be paid off first before your other general unsecured creditors.
Now, there are certain types of debts that you generally cannot discharge. Taxes under some circumstances. My understanding is that taxes that are unpaid, that are from the last 3 years, you generally can't discharge those. Child support and alimony you can't discharge under most circumstances, as well as student loan debt.
That's correct. Those are the big three that people really hear about. Now, there are a few exceptions with taxes and the student loan scenario, but really what they call DSOs, the domestic support obligations, which is any kind of child support or that type of payment is never dischargeable.
Of course, if there is a support payment and you're in a position to file bankruptcy, that's something that the family court can consider in rearranging your obligations.
Yes, that's, as they say, above my pay grade,
Right.
dealing with, different family law courts. But yes, and there's ways that could also potentially be considered a priority debt and paid first if someone is in arrearages with that under a 13, where you could pay that back. But generally, they're never going to be able to be discharged any kind of child support or domestic support obligation.
Now, I was on a program on this network last evening talking about student loans with Tracy Marks' show, and I promised her that I would ask you a few questions about that because we were talking about the Bruner test, which is an analysis that the court will use to look at whether the student loan debtor is suffering some sort of an undue hardship. Now, have you had experience with that?
I've seen a few cases, and I've helped a few debtors resolve some of these situations. Generally, in these cases, rather than go through a full litigation through the bankruptcy court, we've been able to reach out to the student loan creditor and reach some sort of a negotiation or arrangement to either discharge a portion or pay the money within a Chapter 13 plan. But it is very difficult. It's a very high threshold. You essentially have to prove that you'll never, ever be able to pay this money back again under any circumstances.
There has to be a certainty of hopelessness, as the courts refer to it. Is there any difference that you've seen between private student loans and federal student loans with respect to trying to discharge them?
Not much, except for there have been some cases where I've seen where it's the student loan debt is not a real bona fide educational purpose, or the program that they went through, because sometimes you have some of these different types of courses that people can take that aren't necessarily a degree where they from an accredited university where they receive a degree, and it's
like a trade school or something like that.
Yeah. And in some of those situations, I've seen where some of those loans don't qualify for the discharge protections that other types of educational loans provide. But generally, you have to really look into it, and a lot of times you have to go back in time to where the debtor actually was studying, because they may be filing bankruptcy years after they've already completed their studies.
So if you believe that you're going to file bankruptcy or have a reasonable belief that you're going to be filing in the near future, can you continue to purchase things on a credit card if you have reason to think that you're not going to be able to pay that back?
As a general rule, no. In 2005, the bankruptcy code went under some major revisions regarding this very specific point about abuse of the system. It used to be in years past that people would go on a buying spree right up on the eve of filing for bankruptcy. You can't do that anymore. The general rule of thumb, and I use sort of a Publix test, if you will, down here in South Florida, that if a debtor normally uses their American Express card or one of their credit cards, and they're paying something back every month, they may be struggling, they may be underwater and drowning, but if you're using that card to buy food or medicine, you don't have to stop doing that if you think there's a chance you may be filing for bankruptcy in a few months. That's not going to trigger the abuse. Going to BrandSmart or Best Buy and loading up on a brand new TV and electronics and all these kind of things, and then filing for bankruptcy, yes, that's going to raise some red flags and potentially cause a great deal of problems, and those debts may not be dischargeable.
So the general rule is that if the items that you're purchasing on your credit card are necessities, they are things that you need, then you can still discharge that debt even if you knew you're going to file bankruptcy before you made those purchases. But if you're buying luxury items, then that may not be dischargeable for those purchases. But of course, this raises the issue of there's going to be some gray area about things in between the two.
Then there always is. And some of this is incumbent upon the creditor to come in and step in and say, no, this was an abuse, and actually object to the discharge or that particular debt is dischargeable. And there's also a higher panel behind everything, the United States trustee. See, every bankruptcy court, whether it's a 7 or a 13, a trustee is appointed to administer the bankruptcy case. They have two jobs. They administer the bankruptcy case, make sure us attorneys are doing our job, and they also look out for the benefit of unsecured creditors. And if a trustee sees this pattern of abuse, they'll be the first ones to raise the red flag. But it is on a case-by-case basis.
Well, we have to take a short break to hear from our sponsors, and we'll be back with Tom Willis. So we'll take a short break and we'll return.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Altman, Flynn, and Kubler. Our law firm specializes in elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. We offer elder law services, including estate planning, long-term care planning, and preparation of healthcare documents. We strive to plan for your future needs while allowing you to retain as much dignity and independence as possible. To find out more or to make an appointment, call 954-563-4814. That's 954-563-4814. Or visit us online at altmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. I'm here with Tom Willis. He's a bankruptcy and foreclosure attorney with the law firm Brumfield and Willis in Doral, and we've been talking about bankruptcy. And before the break, we were discussing secured and unsecured debt, so I thought I would ask you to distinguish the two.
Okay, that's one of the most important points in any bankruptcy case. The bankruptcy code essentially puts all debts into one of two buckets, a secured and unsecured. Secured, of course, is a mortgage, a note or a lien on a car that an auto finance company has. Anything where there is something tangible that the creditor has that's collateral. And an unsecured debt is pretty much everything else. Credit cards, medical bills, a personal judgment, any kind of general debt that's not secured by an asset.
So how are these things treated in bankruptcy court?
Well, the trust, one of the jobs that the trustee in a bankruptcy case has is to look after the unsecured creditors. So in a Chapter 7 case, the trustee is looking for something that the debtor has that can be liquidated and paid off to the unsecured creditors. That's why if someone has a very expensive car that's paid off, a boat, jet ski, or a large amount of cash just sitting in a bank, that's going to cause some real issues in a Chapter 7 case because the trustee is going to want to get a hold of those assets to distribute. In a Chapter 13 case, it's also important because the amount of one of the biggest questions that always arises is any Chapter 13 payment plan is how much has to be paid to your unsecured creditors in the plan. because many people, when they file for Chapter 13, the reason they file for the 13 is to either cure a default on the mortgage or dealing with some sort of secured creditor, which it's much better to deal with secured creditors in a Chapter 13 than in a Chapter 7. I use this example to kind of let people understand the difference between a Chapter 7 and a Chapter 13 and secured and unsecured creditors. When people take out a mortgage for your home, to buy a home, people sign two documents. You sign a mortgage which puts a lien on your house. You sign a promissory note, which is your personal unconditional promise to repay that debt back to the bank, okay? When someone files a Chapter 7 and they get a Chapter 7 discharge, their personal obligation to repay the note is discharged, meaning that if there's a deficiency after a foreclosure, the bank can never go after you personally because that's discharged. But the bank still retains a lien on the property, so they can come after their secured asset.
Now, is there a difference between property that's held as an individual versus how property, such as a bank account that's held jointly, or jointly held property, how is that dealt with in bankruptcy court if a creditor is trying to go after a joint bank account or something like that?
That's a great question, and that's one of the things that makes bankruptcy a little interesting and a little creative sometimes, is that even though the bankruptcy code has all of these federal rules for dealing with debts, the debts themselves, as well as people's assets, are generally based on state law. For example, here in the state of Florida, we have a very broad protection under the concept of tenancy by the entireties.
Tenancy by the entirety, just so our listeners know, is property that's generally held by a husband and wife.
Correct.
And that's similar to a joint tenancy, which is simply two people that own a property, both of whom have 100% interest in the property.
Right. But the difference with a tenancy by the entireties is if, for example, let's say a husband and wife own an asset under tenancy by the entireties, then the creditor of one spouse cannot garnish or levy or attack that asset that's jointly held by the two of them. So in many of these cases, what is considered part of the bankruptcy estate, what is considered something that a trustee could liquidate, does depend on that question of state law of tenancy by the entireties and whose name that asset is actually held in. Another huge issue that we see a lot is, for example, parents may have a car that one of their adult children drives, but the title is still in their name. So the question then becomes, if the parent files for bankruptcy, whether or not that car is part of the bankruptcy estate.
And what you were saying earlier about the tenancy by the entirety, that goes back to the fact that Florida does not obligate one spouse for the debts of the other, which is very important.
Correct.
So we don't have too much time left. I'd like to get to the MMM program, which is something we were talking about earlier. I wasn't aware of it. I think it's very interesting. It was recently rolled out through the Southern District of Florida federal courts, and it's a way to potentially reorganize your mortgage or reorganize your debts to the bank in the event that you're being foreclosed on at the same time that you're filing for bankruptcy.
That's correct. And, you know, I've been dealing with mortgages and foreclosures since the bottom dropped out of the market back at the beginning of 2008. I've seen hundreds of these cases. And this new program that started off in the Chapter 13 bankruptcy context, while it's not perfect and we're still trying to improve it, if a person wants to save their home and wants to modify their loan, in my opinion, it's the best shot they're going to get. See, the bankruptcy code, specifically Chapter 13, has always been a tool for people to deal with a mortgage default. The bankruptcy code did and still does today allow a person to take all of their past due amount of their debt, all the payments they haven't made over a period of time, file a Chapter 13, begin making their mortgage payments, and spread out that default over a number of years. But for someone who has a great deal of arrearages, that's been a problem. That's where the MMM program comes in. The MMM program allows someone to file a Chapter 13 and begin making payments under the Making Homes Affordable or the HAMP program, where you begin, instead of paying everything you owe past due, which could be tens or hundreds of thousands of dollars in some case, they begin making a good faith payment to the mortgage based on their gross income.
Well, we are running out of time. I'd like to make sure that you can give your contact information in the event that any of our listeners might be in need of your services.
Absolutely. I appreciate that. Our law firm is Brumfield & Willis. We're located in Doral, Florida. Our website is brumfieldwillis.com, BRUMFIELDWILLIS. But I encourage people, if they have a question, they can email me directly. And that's Doral Attorney, like the city of Doral, DORAL, and attorney, ATTORNEY, @gmail.com.
Well, thank you so much, Tom. I'd like to thank my guest, Tom Willis, for joining us this evening. Please tune in next week from 6 to 6:30 on Tuesday, where my guest will be Judy Goodman, public policy attorney, and we'll be talking about the Affordable Care Act. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on